जय हिंद दोस्तों, फिर से आपका स्वागत है हमारे इस विजन IAS पीडी 365 सीरीज में, जिसमें लोग पॉलिटी कर रहे हैं। अभी इसी का आया तो यही कर रहे हैं जो अप्रैल 2023 से लेकर दिसंबर 2023 का पूरा क्लासरूम स्टडी मटेरियल है। और यह बहुत सारे लोगों का मतलब वेट हो रहा था इसका कि कब आए और कब हम लोग शुरू करें। मेरा भी यही वेट हो रहा था। आज हम लोग यहाँ पे सेकेंड टॉपिक में जाने वाले हैं। पार्लियामेंट्री प्रिविलेज ऑफ लॉ मेकर्स में हम लोग चल रहे थे, तो आज हम लोग इसी को कंटिन्यू करने वाले हैं। यह सेकंड वीडियो लेक्चर होगा, तो उम्मीद है आप लोगों ने पहले का देखा होगा। अगर नहीं देखे तो लिंक मैं डिस्क्रिप्शन बॉक्स में डाल दूंगा, आप लोग जाइए प्लेलिस्ट चेक कीजिए। और उसी में आपको विजन वाजीराम एंड रवि का करंट अफेयर का पूरा कंपाइलेशन मिल जाएगा, वो भी देखिए। उसका भी पूरा प्लेलिस्ट बना हुआ है, पूरा सीरीज़ है, और हम लोगों ने सारे वीडियोस बना रहे हैं और अपलोड भी चल रहा है, रेगुलर चल रहा है। तो आप लोग उसे भी देखिए और उससे भी अपना रिवीजन और मौजूद कीजिए। तो आइए शुरू करते हैं हम लोग आज का अपना टॉपिक। मगर शुरू करने से पहले बस यही अनुरोध रहेगा कि अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ 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 इसे सब्सक्राइब करके हमें सपोर्ट करें, जिससे कि आपको भी जब भी हम कोई नया वीडियो डालें तो आप तक नोटिफिकेशन पहुंच जाए। क्योंकि हम लोग एग्ज़ाम मतलब ये UPSC CSE होने से पहले हम लोग काफ़ी सारा मटेरियल अपलोड करने वाले हैं इस पर। तो आप लोग बस हमारे साथ बने रहिए और अपना रिवीजन अच्छे से करते रहिए। आइए शुरू करते हैं। आज से हमारा यहाँ टॉपिक होगा आज का explosion of lawmakers. Why in the news? Recently, Lok Sabha has expelled one of its members accused of accepting gifts and illegal gratification based on the Ethics Committee report. Explosion of lawmakers in India. It can be done on a constitutional as well as legal rules of the House basis. The constitutional basis of exclusion. An MP found guilty of breach of privileges or contempt of the House can be suspended from the House or face exclusion. A simple majority is needed to pass a motion of exclusion in each House. Further, involvement of ethics committee is not always necessary for exclusion. लीगल बेसिस ऑफ सस्पेंशन एंड एक्सक्लूजन ऑफ MPs क्या क्या देख लेते हैं। टू इन्हांस स्मूथ प्रोसीडिंग एंड मेंटेन ऑर्डर, द प्रिसाइडिंग ऑफिसर ऑफ द हाउस हैज़ द पावर टू फोर्स अ मेंबर टू विथड्रॉ फ्रॉम द हाउस इन केसेस ऑफ एक्सट्रीम misconduct. The house may expel a member to read the house of person who are unfit for membership. यहाँ पे एथिक्स कमेटी ऑफ लोकसभा क्या है, तो इट कंसिस्ट of not more than 15 members nominated by the speaker and shall hold office for a term not exceeding 1 year. Functions क्या है, to examine a complaint relating to the unethical condition of a member referred to it by the speaker, make recommendation and formulate a code of conduct for members, suggest amendment to the code of conduct. The first ethics committee of Lok Sabha was set up in 2000 and of Rajya Sabha in 1997. यहाँ पे क्या, रूल्स ऑफ प्रोसीजर एंड कंडक्ट ऑफ बिजनेस रिलेटेड टू सस्पेंशन इन लोकसभा एंड राज्यसभा। तो लोकसभा पहले देखते हैं कि लोकसभा में क्या है। तो रूल 373, इट एम्पावर्ड अ प्रिसाइडिंग ऑफिसर टू ऑर्डर एन MP टू विथड्रॉ ड्यूरिंग द रिमाइंडर ऑफ द डेज सिटिंग। फिर रूल 374 क्या है, तो allows to suspend the MP for a period not exceeding the remainder of the suspension. Rule 374A क्या है, तो brought in 2001 allow the speaker to name an MP who will then automatically stand suspended for 5 days or the remaining part of the session, whichever is less. और उसी तरह से रूल इन राज्यसभा देख लेते क्या है, तो रूल 255, it allows the chairman to direct any member to withdraw immediately from the house for disorderly conduct. Rule 256, House may adopt a motion suspending the member disregarding chair's authority or abusing the rules for a period not exceeding the remainder of the session. Unlike the Lok Sabha, under Rule 374A, the Rajya Sabha cannot suspend its member without passing a motion. आर्टिकल 122 क्या है ऑफ द कॉन्स्टिट्यूशन सेज, क्या बोलता है, पार्लियामेंट्री प्रोसीडिंग इंक्लूडिंग दोज रिलेटेड टू एक्सप्लोजन कांट बी क्वेश्चन बाय द जुडिशरी ऑल्दो द कोर्ट हैव इंटरवीन्ड इन सम केसेस. इन द राजा रामपाल केस 2007, द कोर्ट अपहेल्ड द एक्सप्लोजन ऑफ राजा रामपाल बट नोटेड दैट proceeding tainted by substantial illegality are open to judicial scrutiny. Exclusion and disqualification are not the same. The Constitution provides for both exclusion and disqualification. Under disqualification, member of the parliament cannot contest the election further, while under exclusion he or she can. Disqualification of a lawmaker. RPA 1951 under section 8 Clause 4, a lawmaker is disqualified for the period of imprisonment and a further 6 years if sentenced for 2 years or more in prison. 10th Schedule of the Constitution provides for the disqualification on ground of defection. Article 102 Clause 1 and Article 191 Clause 1 for disqualification of a MP and a MLA respectively on grounds of holding an office of profit, being of unsound mind or insolvent or not having valid citizenship. अगला हेडिंग है एंटी डिफेक्शन लॉ. तो क्या है? वाई न्यूज़. तो महाराष्ट्र स्पीकर डिसमिस्ड all petitions seeking the disqualification of MLAs under anti-defection law. About anti-defection law क्या है? तो anti-defection law was included under the 10th schedule via the 52nd Amendment Act of 1985. Any question regarding disqualification arising out of defection is to be declared by the presiding officer of the House. Disqualification happens if a member voluntarily give up his party membership or votes abstain to vote in the House contrary to the direction issued by his political party, and such act has not been condemned by the party within 15 days. An independent member becomes disqualified if he or she joins any political party after such an election. A nominated member becomes disqualified if she or he joins any political party after the expiry of 6 months from the date on which he has taken a seat. Exception क्या है? तो law allows a political party to merge with or into another party provided that 2/3 of its total legislators are in favor. If a person is elected as a Speaker of Lok Sabha, Deputy Speaker and Deputy Chairman of Rajya Sabha, then he could resign from his party and rejoin the party once he or she deems the post. Presently, the law does not provide a time limit within which the presiding officer have to decide on the anti-defection case. विप क्या? तो विप देख लेते हैं. रूल 2 of the anti-defection law puts the party member into a bracket of obedience to the party whip and policies. In parliament parlances, a whip may refers to क्या है? तो a written order for party member to follow a certain direction and a designated official to the party who is authorized to issue such a direction. The term originates from the British practice of whipping in. Lawmaker is follow the party line. Judicial pronouncement related to 10th schedule क्या क्या? तो देख लेते हैं. Kyoto Holohol versus Jinjulu 1992. Supreme Court held that Speaker's decision under anti-defection law is subject to judicial review. और उसी तरह से केशम मेगा चंद्र सिंह 2020 case, Supreme Court ruled that disqualification petition under the 10th schedule should normally be decided within a period of 3 months from the date of their filing. Supreme Court also noted the issue of partisan behavior on the part of speakers due to their political allegiance and suggested a permanent tribunal to decide case under 10th schedule. अगला वाला टॉपिक है ऑर्डिनेंस मेकिंग पावर ऑफ प्रेसिडेंट एंड गवर्नर. तो क्या है ऑर्डिनेंस मेकिंग पावर? वाई न्यूज़ में क्यों आया? देख लेते हैं. A recent analysis showing that the number of ordinances issued by the president has dropped since 2019. In 2022, for the first time in 59 years, no ordinances were promulgated. Ordinance making power of the president and governor. Ordinances are temporary law which can be issued by the president when parliament is not in session. Power to promulgate the ordinance can be traced from Indian Council Act of 1861, the Government of India Act GOI Act 1909 and the Government of India Act of 1935. The ordinance is listed under Article 123, power of President to promulgate ordinance during recess of Parliament, and Article 213, power of Governor to promulgate ordinance during recess of legislature. These promulgated ordinances have the same force and effect as an act of legislature, but these acts are likely in temporary nature. An ordinance ceases to operate at the expiration of 6 weeks from the date when the next session starts. If the two houses start their session on different dates, the latter of the date will be considered. The ordinance may lapse earlier if the president or governor withdraw it or if both houses passes a resolution disapproving it. In case of a state legislature, resolution disapproving it is passed by legislative assembly and agreed to by the legislative council if any. Ordinance can only be issued on matter on which parliament or legislature can make laws and are subject to same limitation as parliament legislature to make laws. However, the governor of a state cannot make an ordinance without the reference of the president in the following case. तो कौन कौन सा केस है देख लेते हैं. पहला, if bills containing similar provision would have required the prior sanction of the president for introduction in the assembly. दूसरा, if governor would have deemed it necessary to reserve a bill containing similar provision for consideration of the president. और तीसरा, if an act of a state legislature containing the same provision would have been invalid without receiving the president assent. जुडिशियल प्रोनाउंसमेंट रिलेटेड टू ऑर्डिनेंस क्या क्या देख लेते हैं. तो आरपी कॉपर वर्सेस यूनियन ऑफ इंडिया 1970, इसमें बोला था एपेक्स कोर्ट हेल्ड दैट प्रेसिडेंट्स डिसीजन कुड बी चैलेंज्ड ऑन द ग्राउंड ऑफ immediate action was not required and the ordinance had been passed primarily to bypass debate and discussion in the legislature. DC Wadhwa versus State of Bihar 1987, court held that legislative power of executive to promulgate ordinance is to be used in exceptional circumstances and not as a substantiate for law making power of the legislator. अगला है कृष्ण कुमार सिंह वर्सेस स्टेट ऑफ बिहार 1994, court held that the satisfaction of the president under article 123 and governor under article 213 while issuing an ordinance is not immune from judicial review. अगला टॉपिक है सेक्रेटेरिएट ऑफ द पार्लियामेंट. न्यूज़ में क्यों रहा? तो एज द पार्लियामेंट कंप्लीट 75 years, the parliament secretariat have been the custodian of procedure, precedent and legislative knowledge of the two houses. Constitutional provision क्या है? तो आर्टिकल 98, each house of parliament shall have a separate secretariat staff. Parliament may by law regulate the recruitment and the condition of service of person appointed to the secretariat staff of either house. However, so far no such law has been passed. It also allows the creation of posts common to both the House of Parliament. Article 187 makes similar provision for the Secretariat of State Legislature, Council of a State Secretariat and Parliament Secretariat for House of the People were set up when both houses came into existence in 1952. Their names were changed in 1954 to Rajya Sabha Secretariat and Lok Sabha Secretariat respectively. The Secretariat of both houses has been divided into 10 services on a function basis like legislative, executive, administrative, verbatim, reporting service, etc. Speaker and chairman can create new posts in respective secretariat. However, the post in class 1 or class 2 prior consultation with the Union Ministry of Finance is mandatory. Secretary General of both houses hold rank equivalent to that of Cabinet Secretary. However, in the table of precedence, the Cabinet Secretary is placed at the 11th position, whereas the Secretary Lok Sabha या Rajya Sabha are placed at the 23rd position. फंक्शन ऑफ सेक्रेटेरिएट क्या है देख लेते हैं. तो सेक्रेटेरिएट असिस्टेंस फॉर इफेक्टिव फंक्शनिंग ऑफ द हाउस ऑफ द पार्लियामेंट, पेमेंट ऑफ सैलरी एंड अदर अलाउंस, servicing various parliamentary committee. Secretary General aid and advise the presiding officer, prepare research and reference material and bring out various publications, prepare and publish a record of the day-to-day proceedings of the house. स्ट्रक्चर ऑफ सेक्रेटेरिएट क्या है? तो लोकसभा सेक्रेटेरिएट देखते हैं पहले. स्पीकर लोकसभा वेस्टेड विथ अल्टीमेट गाइडेंस एंड कंट्रोल ओवर द सेक्रेटेरिएट. एडमिनिस्ट्रेटिव हेड कौन है? सेक्रेटरी जनरल. रिक्रूटमेंट एंड कंडीशन ऑफ सर्विस क्या होगा? तो गवर्नड बाय द लोकसभा सेक्रेटेरिएट. रिक्रूटमेंट एंड कंडीशन ऑफ सर्विस रूल्स 1955 प्रोमोलगेटेड बाय द प्रेसिडेंट इन कंसल्टेशन विद स्पीकर. उसी तरह से राज्यसभा सेक्रेटेरिएट देखते हैं. तो चेयरमैन राज्यसभा का वेस्टेड विथ एडमिनिस्ट्रेटिव कंट्रोल ओवर द सेक्रेटेरिएट. एडमिनिस्ट्रेटिव हेड कौन है? तो सेक्रेटरी जनरल. रिक्रूटमेंट एंड कंडीशन ऑफ सर्विस गवर्नड बाय द राज्यसभा सेक्रेटेरिएट. रिक्रूटमेंट एंड कंडीशन ऑफ सर्विस रूल 1957 प्रोमलगेटेड बाय द प्रेसिडेंट इन कंसल्टेशन विथ चेयरमैन सिमिलर टू लोकसभा। अगला टॉपिक है हमारा डेमोक्रेटिक डिसेंट्रलाइजेशन इन इंडिया। न्यूज़ में क्यों था? तो द ईयर 2023 मार्क्स द 30th एनिवर्सरी ऑफ द 73rd and 74th अमेंडमेंट ऑफ इंडियन कॉन्स्टिट्यूशन। Democratic decentralization in India. It refers to the devolution of power, resource, and decision-making authority from the central government to the local government, such as panchayat and municipalities. The 73rd and 74th Constitutional Amendment Act of 1992, that came into force in 1993, introduced democratic decentralization in India. तो 73rd Constitutional Amendment Act 1992 क्या था? तो पंचायती राज institution was constitutionalized through the act. The act has added a new part 9 to the Constitution of India and consists of provision from Article 243 to 243O. It added a new 11th schedule to the Constitution that contained 29 functional items of the Panchayat. 74th Constitutional Amendment Act 1992 क्या था? तो urban local government were centralized, constitutionalized. It added Part 9A and consists of provision from Article 243P to 243ZG. It also added the 12th schedule to the Constitution that contained 18 functional items of municipalities. Step taken to strengthen RPIs in India. राष्ट्रीय ग्राम स्वराज अभियान RGSA for developing and strengthening the capacities of RPIs. E-Gram Swaraj, a user-friendly web-based portal that unifies the planning, accounting and monitoring function of Gram Panchayat. People's Gram Campaign PPC, सबकी योजना सभा विकास. To draw up Gram Panchayat Development Plan GPDPs. Backward Region Grant Fund BRFGF. United funds are given for meeting critical gap in local infrastructure and development in some identified backward district. National Institute for Rural Development and Panchayati Raj, an autonomous organization under the Ministry of Rural Development for capacity building of rural development functionaries, local elected representative, banker, NGOs, etc. National Panchayat Award क्या है? तो यूज अंडर दिस बेस्ट परफॉर्मिंग पंचायत आर अवॉर्डेड बेस्ड ऑन वेरियस क्रिटेरिया एंड इंडिकेटर्स. स्वामित्व स्कीम, तो ये क्या है? तो प्रोवाइड द रिकॉर्ड ऑफ राइट्स टू विलेज हाउस होल्ड ऑनर एंड इश्योरेंस ऑफ प्रॉपर्टी कार्ड टू द प्रॉपर्टी ऑनर. इंपॉर्टेंट पंचायती राज कमेटी कौन कौन सा? तो देख लेते हैं. पहला है बलवंत राय मेहता कमेटी 1957. दूसरा अशोक मेहता कमेटी 1977 1978. इसी तरह से अगला है CH हनुमंता राव वर्किंग ग्रुप 1983. फिर है GVK राव कमेटी 1985. अगला है LN सिंघवी कमेटी 1986 और फिर है तुंगन कमेटी 1988. नेक्स्ट टॉपिक इज फाइनेंस ऑफ पंचायती राज इंस्टीट्यूशन PRIS, फाइनेंसेस ऑफ पंचायती राज इंस्टीट्यूशन. तो न्यूज़ में क्यों रहा? तो रिसेंटली द रिजर्व बैंक ऑफ इंडिया RBI रिलीज्ड इट्स रिपोर्ट टाइटल्ड फाइनेंसेस ऑफ पंचायती राज इंस्टीट्यूशन. द रिपोर्ट डिस्कसेस द फिजिकल पोजीशन of PRIs for the year 2020, 21 to 22, 23. Constitutional provision to financial empowerment of panchayat क्या क्या है? तो Article 243H provides to finance for the panchayats by securing authorization from state legislator for grant in aid to the panchayats for the consolidated fund of the state. It empowered panchayats to impose, collect and allocate taxes, duties, tolls and fees. Article 243I, setting up a State Finance Commission FCs every 5 years to review the financial position of panchayats and make recommendation to improve their financial position. Article 280 Clause 3 Subclause BB mandates Central Finance Commission to recommend measures needed to augment the consolidated fund of the state and supplement panchayat resources. Sources of finance for PRIs. Internal या own source of revenue. Tax revenue for property tax on land other than agricultural land or building or both. Taxes and on duties and commodities. Service tax, tax on profession, trade, etc. Non-tax revenue from market fee on persons exporting goods for sale in panchayat areas, fee in registration of cattle sold within the panchayat area, etc. अगला ट्रांसफर ऑफ फंड्स फ्रॉम सेंट्रल फाइनेंस कमीशन CFCs एंड स्टेट फाइनेंस कमीशन SFC. उससे पहला है टाइड ग्रांट्स आर मार्क्ड for a specific purpose or sector like sanitation, education, etc. United grants, general purpose grants. These are provided without specific condition or restriction and can be utilized for local need and priorities. Performance based grants, additional fund granted to PRIs based on recommendation of CFCs and specific performance criteria. अगला स्पेशल कैटेगरी ग्रांट्स. These grants are additional finance support designed to address unique challenge or particular needs of PRIs in a specific region or context. अगला other sources. Transfer from central government and state government under different schemes like मनरेगा, PMI, rulers, संसद आदर्श ग्राम योजना etc. Grants for international bodies like World Bank etc. अगला है कैपेसिटी बिल्डिंग फॉर अर्बन लोकल बॉडीज ULBs. तो न्यूज़ में क्यों रहा? तो रिसेंटली द कैपेसिटी बिल्डिंग कमीशन CBC इन कोलैबोरेशन विथ MOHUA ऑर्गेनाइज्ड ए नेशनल वर्कशॉप ऑन कैपेसिटी बिल्डिंग ऑफ ULBs टू फोस्टर अ यूनिफाइड अप्रोच टू कैपेसिटी बिल्डिंग ULBs अक्रॉस इंडिया. More on news. The workshop marked the launch of 3 key initiatives, that is, Annual Capacity Building Plan ACBP to enhance the capacities of MOHUA, ACBP 46 pilot ULBs. कौन कौन सा कहाँ कहाँ? तो अहमदाबाद, भुवनेश्वर, मैसूर, राजकोट, नागपुर एंड पुणे. Comprehensive toolkit for preparing capacity building plan for ULBs for providing valuable resource to facilitate the growth and development of ULBs. About urban local bodies. ULBs are small local bodies that administer or govern a city or a town of a specified population. Urban governance. Local government is part of a state list entry number 5 under the Constitution. Thus, the administrative framework and regulation of ULBs varies across states. Constitution 74th Amendment Act 1992 formally recognized urban local government as the third tier of government. The act provided for the establishment of 3 types of ULBs. पहला है नगर पंचायत for a transitional area. दूसरा है municipal council for a smaller urban area and तीसरा है municipal cooperatives for a larger urban area. अब देख लेते कैपेसिटी बिल्डिंग कमीशन क्या है. CBC. तो जेनेसिस क्या है? तो कॉन्स्टिट्यूटेड थ्रू गैजेट ऑफ इंडिया इन 2021. अबाउट. तो इस्टेब्लिश एज एन इंडिपेंडेंट बॉडी विथ कंप्लीट एग्जीक्यूटिव एंड फाइनेंशियल अथॉरिटी. इट इज़ की कंपोनेंट ऑफ नेशनल प्रोग्राम फॉर सिविल सर्विसेज कैपेसिटी बिल्डिंग NPCSCB मिशन कर्मयोगी. सर्व्ड एज डिपार्टमेंट ऑफ पर्सनल एंड ट्रेनिंग. पर्पस क्या है? तो टू बिल्ड credibility and shape a uniform approach to capacity building on a collaborative and co-sharing basis. Composition क्या है? तो a chairperson and 2 members supported by an internal secretariat headed by secretary in the grant of joint secretary. Function क्या है? तो coordinate with department of government for evolving a harmonious desolid approach to improve capacity and build shared resources. Prepare annual HR report on health of civil services along the target achieved. Undertake audit of human resource available in government and access outcome of capacity building efforts. Measures taken for capacity building of ULBs. तो क्या है measures देख लेते हैं. National Urban Digital Mission launched in 2021 by MOHUA. It focuses on citizen-centric digital revolution in ULBs in India. It aims to create a shared digital infrastructure working across 3 pillars of people, processes and platform to provide a framework for digital governance in the country. National Institute of Urban Affairs NIUA has been appointed to anchor this mission. Established in 1976, NIUA is a premier institute for research, training and information dissemination in urban development and management. Municipal bonds क्या है? तो these are financial institutions that municipal corporation and other associated bodies in India issued to raise fund. अगला हेडिंग है पंचायत एक्सटेंशन ऑफ द शेड्यूल्ड एरिया एक्ट 1996. न्यूज़ में क्यों था? तो रिसेंटली झारखंड इश्यूड द पंचायत एक्सटेंशन टू शेड्यूल्ड एरिया एक्ट पेसा एक्ट Draft rule for public consultation about PESA Act 1996. तो क्या है देख लेते हैं. Based on recommendation of the Dilip Singh Bura Committee, the PESA Act was enacted in 1996 for tribal empowerment and to bring them into the mainstream. It provides for the extension of provision of Part 9 of the Constitution relating to Panchayat to scheduled area of 10 states under Article 244, Clause 1, read with Schedule 5 with certain modification and expectations. PESA empower the state legislature to frame laws in this regard. Presently 10 states via कौन कौन सा तो देख लेते हैं. आंध्र प्रदेश, छत्तीसगढ़, गुजरात, हिमाचल प्रदेश, झारखंड, मध्य प्रदेश, महाराष्ट्र, उड़ीसा, राजस्थान एंड तेलंगाना have fifth schedule area in their respective states. 8 states except Jharkhand and Odisha have framed and notified their state PESA rules under the respective state Panchayati Raj Act. The Ministry of Panchayati Raj is the nodal ministry for the implementation of provision of PESA in the state. PESA Act is called a constitutional within the Constitution. The major power of Gram Sabha under PESA देख लेते हैं कौन कौन सा. तो पावर ऑफ मैंडेटरी consultation in a matter of land acquisition, prevent alienation of land and restore alienated land, to control institutions and functionaries in all social sector and local plans, to manage minor water bodies, ownership of minor forest produce, regulate and restrict sale consumption of liquor, manage village market, control money leading to scheduled tribes, resettlement and rehabilitation, and prospecting license, mining, lease for minor minerals. अदर फीचर ऑफ पेसा एक्ट 1996. तो उसमें क्या क्या है तो देख लेते हैं. कंफर्मिटी विथ कस्टमरी लॉ. स्टेट लेजिस्लेशन ऑफ पंचायत शैल बी इन कंफर्टिविटी with customary law. Social and religious practices and traditional management practices of community resources. Gram Sabha. Every village shall have a Gram Sabha GS consisting of persons whose names are included in electoral roll for panchayat at village level. अगला रोल एंड रिस्पॉन्सिबिलिटी ऑफ ग्राम सभा. तो क्या है देख लेते हैं. तो ग्राम सभा है रोल एंड रिस्पॉन्सिबिलिटी इन अप्रूविंग ऑल डेवलपमेंट वर्क. इफ village identify beneficiaries, issue certificates of utilization of fund, power to control in institution and functionaries in all social sector and local plans. Every GS to safeguard and preserve tradition and custom of people, their cultural identity, community resource and the customary mode of dispute resource. Reservation क्या था तो every panchayat to have reservation of seats in proportion to community population, minimum of 150% with chairperson of panchayat at all level to be reserved for STs. फिफ्थ एंड सिक्स्थ शेड्यूल क्या है तो देख लेते हैं आगे करके. तो पहले देखते हैं फिफ्थ शेड्यूल के बारे में. तो कॉन्स्टिट्यूशनल प्रोविजन क्या है तो आर्टिकल 244 क्लॉज 1 प्रोवाइड फॉर द फिफ्थ शेड्यूल अप्लाई टू द एडमिनिस्ट्रेशन एंड कंट्रोल ऑफ द शेड्यूल एरिया एंड शेड्यूल ट्राइब इन एनी स्टेट एक्सेप्ट स्टेट ऑफ असम, मेघालय, त्रिपुरा एंड मिजोरम. काउंसिल क्रिएशन क्या है तो बाई एक्ट ऑफ अ स्टेट लेजिस्लेटर. ऑटोनॉमी क्या है तो पंचायत एक्सटेंशन टू शेड्यूल एरिया एक्ट 1996. सेल्फ गवर्नेंस थ्रू ग्राम सभा फॉर पीपुल लिविंग इन फिफ्थ शेड्यूल एरिया. फिफ्थ शेड्यूल ट्राइबल एडवाइजरी काउंसिल हैज़ ओनली एडवाइजरी पावर. सिक्स शेड्यूल में देखते हैं तो क्या है कॉन्स्टिट्यूशनल प्रोविजन क्या है तो आर्टिकल 244 क्लॉज 2 and 275 clause 1 provide for administration of the tribal areas in Assam, Meghalaya, Tripura and Mizoram. Council creation क्या है तो autonomous district council ADC provided by constitution. Autonomy क्या है तो greater autonomy compared to fifth schedule and ADCs have much wider power than tribal advisory council. Other important news में क्या क्या देख लेते हैं. पहला है panel of vice chairpersons VCs. Rajya Sabha chairman constituted an all-women panel for VCs in Rajya Sabha. Under the rules of Rajya Sabha, the chairman nominates from among the members of a panel of VCs. Any one of them can preside over the house in the absence of chairman or deputy chairman. However, they cannot preside over the house when the seat of chairman or deputy chairman is vacant. In this case, President appoints a member of the House to perform the chairman's duty. He or she have the same power as the chairman when presiding and holding office unit until a new panel of VCs is nominated. Parliament succession. Parliament sessions. The Constitution of India did not mention the term special session. The term sometimes refers to sessions government has convened for specific occasions. Article 83 mandates that Parliament should meet at least twice a year. The gap between two sessions should not exceed 6 months. By convention, Parliament meet for 3 sessions in a year. However, the provision does not prevent the summoning of Parliament more often, and these extra sessions are referred to as special sessions. The Cabinet Committee on Parliamentary Affairs determines the date and duration of parliamentary sessions. The President then summons MPs for the session. अगला immunity for President. Supreme Court SC held that government cannot claim immunity for application of law to a contract merely because one of the parties to it is the President. SC said Article 299 contract made by the Union of State in name of President or Governor does not give the government power to break the statutory law. Article 361 of the Indian Constitution grant immunity or protection to the President and the Governor of the country. President and the Governor are immune from court scrutiny for their action and duties in office. Conduct of the President can be reviewed only if either House of Parliament designate court or tribunal or any other body to investigate the charges under Article 61. Rule 176 and Rule 267. According to the rules of procedure and conduct of business in the Council of State, Rule 176 allows for a short duration discussion, not exceeding 2.5 hours on a particular issue. Under Rule 276, a Rajya Sabha MP has the special power to suspend the pre-decided agenda of the House with the approval of the chairman. अगला adjournment motion moved in the Lok Sabha for discussing a definite matter of urgent public importance with the Speaker consent. It needs the support of 50 members to be admitted. It involves an element of censure against the government, and hence Rajya Sabha is not permitted to make use of this device. Discussion on an appointment motion should last for not less than 2 hours and 30 minutes. अगला subordinate legislation और delegate legislation. Committee on Subordinate Legislation of Rajya Sabha released delay in framing of rules under various acts by the Ministry's report. Scheduled legislation is the legislation made by an authority subordinate to the legislator. Most enactment delegate the power for making rules, regulations, bylaws, etc. to subordinate authorities like the executive. Need for subordinate legislation. Legislators have limitations of time. Thus, subordinate legislation is practical necessity. Enable experts and technocrats to provide detail with the framework of law. Committee on Subordinate Legislation, Rajya Sabha, constituted under the Rule 204 of Rules of Procedure and Conduct of Business in Council of State. Mandate क्या है तो scrutinize and report the House whether the power of subordinate legislation delegated by Parliament have been properly exercised. अगला Parliament security breach. Recently, Parliament security was breached where accused entered Lok Sabha on Victor's Pass and releases color gas canister emitting yellow smoke, restricted across to Parliament. Rules of Procedure and Conduct of Business in Lok Sabha deals with admission, withdrawal and removal of stranger. It specifies that a Speaker, whenever think fit, may order the withdrawal of stranger from any part of the House. Visitor to parliament need security clearance for parliamentarians from parliamentarians. अगला है सरपंच पति. Standing Committee on Rural Development and Panchayati Raj recommended training and capacity building to curb prevalent concept like Sarpanch Pati or Pradhan Pati. It refers to practice of husband act as proxy for elected women and wield the actual political decision making power. Women reservation in Panchayati Raj institution PRIs. 73rd Constitutional Amendment Act of 1992. One third of seat of PRIs and one third officer of chairperson at all level of PRIs covered by Part 9 are reserved for women. Article 243D. Many states like Bihar, Kerala, Maharashtra, Odisha, Rajasthan, etc. have made legal provision for 50% reservation of women among members and sarpanch. As per Women and Male in India 2022 report, over of the over 31.8 lakh ERs, nearly 46 over 14.5 lakh were women. अगला है कोटा टू बैकवर्ड क्लासेस इन अर्बन लोकल बॉडीज ULBs. Haryana Cabinet has accepted State Backward Classes Commission's report on proportion of reservation of backward class Block A category in ULB. Article 243T, Clause 6. There will be no bar or state legislator for making provision for reservation of seats in any municipality or office of chairperson in municipalities in favor of backward class of citizen. ट्रिपल टेस्ट कंडीशंस फॉर रिजर्वेशन ऑफ ओबीसीज इन लोकल बॉडीज के कृष्णमूर्ति वर्सेस यूनियन ऑफ इंडिया 2010. उसमें 3 चीज़ हुआ था. क्या हुआ? पहला, सेट अप डेडिकेटेड कमीशन टू कंडक्ट ए रिगोरस empirical inquiry in nature and implications of backwardness in local bodies. दूसरा है specify the proportion of reserved required in local bodies in light of commission's proposal. तीसरा है ensure reservation for scheduled caste, scheduled tribes, OBC taken together does not exceed an aggregate of 50% of total seats. अगला हमारा तीसरा सेक्शन है सेंटर स्टेट रिलेशन. उसमें पहला है रोल ऑफ गवर्नर. तो गवर्नर का रोल क्या है? तो न्यूज़ में ये क्यों रहा? तो पहले रिसेंटली केरला, तमिलनाडु एंड पंजाब मूव द सुप्रीम कोर्ट अगेंस्ट देयर रिप्रेजेंटेटिव गवर्नर ओवर द पेंडिंग बिल. कॉन्स्टिट्यूशनल प्रोविजन रिगार्डिंग बिल बिफोर गवर्नर क्या है? तो आर्टिकल 200. असेंट द गवर्नर इज नेसेसरी. Assent of the governor is necessary for a bill to become a law. In this regard, the governor has been given some options. क्या क्या ऑप्शन है देख लेते हैं. तो गवर्नर्स ओपिनियन और स्टेटस ऑफ द बिल. गिव असेंट टू द बिल देन बिल बिकम अ लॉ. विड्रॉ द असेंट देन बिल फेल्स टू बिकम अ लॉ. तीसरा है रिटर्न द बिल फॉर रिकंसिडरेशन ऑफ द लेजिस्लेटर. इफ द स्टेट लेजिस्लेटर passes the bill in its original shape or in a modified form, the governor has to give the assent to re-enacted bill. और दूसरा क्या है? The constitution does not lay down any time limit within which the governor is required to return the bill for reconsideration if not insist on as soon as possible. और चौथा क्या है? reserve the bill for the consideration of the president. Any bill which is in the option of the governor would, if it become law, so derogate from the power of the high court as to endanger the position which that court is by this constitution designated to fill. Reserving bill for president. Article 201. President can either give his assent or withdraw the assent. इसमें देखते हैं और क्या है? तो प्रेसिडेंट में डायरेक्ट द गवर्नर टू रिटर्न द बिल टू स्टेट लेजिस्लेटर with his or her message. Such bill, if re-enacted by the state legislator with or without amendment, is presented again to the president. यहाँ पे देख लेते हैं कॉन्स्टिट्यूशन प्रोविजन रिलेटेड टू गवर्नर और जुडिशियल प्रोविजन रिलेटेड टू गवर्नर. तो पहले देखते हैं कॉन्स्टिट्यूशनल प्रोविजन रिलेटेड टू गवर्नर. आर्टिकल 153. देयर शैल बी ए गवर्नर फॉर ईच स्टेट. Article 154. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him as per the Constitution. Article 155. Governor of a state shall be appointed by the President by warrant under his hand and seal. Article 161, Governor shall have the power to grant, pardon, deprive, etc. Article 163, there shall be Council of Ministers (COM) with the Chief Minister as at the head to aid and advise the Governor in the exercise of his functions except in so far as he is by or under the Constitution required to exercise his function or any of them in his discretion. Article 164, the Governor appoints Chief Minister and other ministers. Article 213, Governor may promulgate the ordinance under certain circumstances. Article 217, Governor is consulted for appointment of judges of High Court. उसी तरह से देखते हैं जुडिशियल प्रोनाउंसमेंट रिलेटेड टू गवर्नर क्या क्या, तो देख लेते हैं। तो पहला है शमशेर सिंह केस 1974, सुप्रीम कोर्ट हेल्ड दैट द गवर्नर डज नॉट एक्सरसाइज डिस्क्रिशनरी पावर वाइल withholding assent or returning a bill to the state legislator. Next is Nawam Rabia case 2016. If a governor exercises his discretion beyond his jurisdiction or power, it would fall under the subject matter of judicial review. फिर से नवाम राबिया केस 2016 फिर से उसमें है if a governor exercise his discretion beyond his judicial power, jurisdiction or power, it would fall under the subject matter of judicial review. वो रिपीट हो गया, सेम है। अगला रिसेंट जजमेंट कौन कौन सा, तो स्टेट ऑफ पंजाब केस 2023, if a governor decides to withdraw assent to a bill, then he or she has to return the bill in the legislature for recommendation. Such a bill cannot be kept with the governor indefinitely. Vice Chancellor case 2023, governor acting as a university chancellor are not bound by the aid and advice of the COM. Tamil Nadu governor case 2023, the governor cannot refuse the bill to the president after the assembly has reenacted the bill following the governor's withdrawal of assent. अगला है कोऑपरेटिव फेडरलिज्म। तो ये न्यूज़ में क्यों रहा, तो प्राइम मिनिस्टर रिसेंटली अंडरलाइंड द इम्पोर्टेंस ऑफ कोऑपरेटिव फेडरलिज्म इन इंडिया। अबाउट कोऑपरेटिव फेडरलिज्म क्या है, तो देखते हैं। कोऑपरेटिव फेडरलिज्म इज द हॉरिजॉन्टल रिलेशनशिप बिटवीन यूनियन एंड स्टेट and so neither is above the other. It envisages the nation and state agencies undertake government functions jointly rather than execute exclusively. Constitutional provision to promote cooperative federalism in India. तो क्या क्या है, तो 7th schedule which demarcates central, state and concurrent list based on the principle of subsidiarity all India service under Article 21312. Integrated judicial system to enforce both state as well as central law. Interstate Council under Article 263 to discuss and investigate the subject of common interest between the center and the state. Article 261 provides that full faith and credit shall be given throughout the territory of India to all the public act, records and judicial proceeding of union and every state. अगला zonal council were established as statutory body under the State Reorganization Act of 1956 to ensure coordination. Article 280, Finance Commission for recommending the distribution of financial resource between the union and the state. Article 279A, GST Council involving members from union and state responsible for deciding the rates of GST and the modalities of its implementation. अगला स्टेप सेकेंड टू फॉस्टर कोऑपरेटिव फेडरलिज्म इन इंडिया क्या क्या है, the share of states in central tax revenue has been increased from 32% to 42% after the recommendation of 14th Finance Commission. Restructuring of centrally sponsored scheme. अगला फाइनेंशियल सेक्टर बेल आउट प्रोग्राम अंडर उज्ज्वल डिस्कॉम एश्योरेंस योजना उदय स्कीम. अगला नेशनल इंस्टीट्यूशन फॉर ट्रांसफॉर्मिंग इंडिया आयोग नीति आयोग act as a platform to promote cooperative federalism. Various steps taken by नीति आयोग are. पहला है सब ग्रुप्स ऑफ चीफ मिनिस्टर ऑन सब्जेक्ट ऑफ नेशनल इंपॉर्टेंस. दूसरा है लॉन्चिंग ऑफ द एस्पिरेशनल डिस्ट्रिक्ट प्रोग्राम फॉर द डेवलपमेंट ऑफ बैकवर्ड डिस्ट्रिक्ट. तीसरा है फ्रेमिंग मॉडल लॉज for land leasing and agriculture market reforms. Next is area specific interventions for the northeastern and Himachal state and island development. Next is subordinate action for transferring human capital SAT program to initiate transformation in the education and health sector in India. Our next topic is interstate border dispute, जिसे हम लोग अगले वीडियो लेक्चर में करेंगे। इसे हम यहीं पे समाप्त करते हैं। उम्मीद है आपको यह वीडियो लेक्चर पसंद आ रहा होगा, तो आप लोग कमेंट बॉक्स में जरूर बताएंगे आपको हमारी यह पहल कैसी लगी। और अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ 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 इसे सब्सक्राइब करके हमें सपोर्ट करें, क्योंकि आपके सपोर्ट की हमें बहुत आवश्यकता होती है और इसी से हमें प्रोत्साहन मिलता है। और वीडियो को ज़्यादा से ज़्यादा शेयर करें उन लोगों तक जो इस बार के यूपीएससी एग्जाम देने वाले हैं, उन तक इसे जरूर पहुँचाएं ताकि उसका रिवीजन अच्छे से हो सके। और इसमें हम लोग सारा का सारा बुक करने वाले हैं, तो आप लोग बिल्कुल भी निश्चिंत रहें, बस हमारे साथ बने रहें, पढ़ते रहें और रिवीजन करते हैं। मिलते हैं आपसे अगले वीडियो लेक्चर में, तब तक के लिए जय हिंद, जय भारत।